Welcome everyone. This webinar is sponsored by the National Resource Center for Adoption, also called NRCA. My name is Melinda List and I'm the Center Director. The NRCA is charged by the Children's Bureau with the task of building the capacity of states, tribes, and territories to improve adoption systems, integrate policy and practice, and develop, expand, strengthen, and improve the quality and effectiveness of adoption services provided to children and youth in the child welfare system. The NRCA also helps jurisdictions improve the effectiveness and quality of permanency support and preservation services. This assistance is provided through tailored technical assistance as well as the development of tools that can be used by states, territories, and tribes to improve components of their child welfare system related to adoption. For more information about the services of the NRCA, please visit us at www.nrcadoption.org, or you may also call us at 248-443-0306. I would like to welcome everyone to Part 2 of our two-part presentation, Understanding and Complying with Title VI of the Civil Rights Act of 1964 and the Multi-Ethnic Placement Act of 1994 as amended. Our webcast is scheduled for approximately 120 minutes. To eliminate background noise during the presentation, all phone lines will be muted for the duration of our webinar. There will be an opportunity for Q&A during the presentation. During the Q&A portions of our webinar, you may ask questions or submit comments by typing in the chat window, which is located at the left of your screen. When finished typing, click on the Send button to submit your questions and comments. For those who would like to speak directly with presenters, you must join the audio portion of this webinar by calling 1-800-763-6049. Excuse me, 1-800-763-6049. Our presenters will answer as many questions as time permits. After the conclusion of our presentation, additional questions and comments may be emailed to nrc@nrcadoption.org. I'd now like to introduce Rose Handon. Rose is the Regional Lead Consultant for the National Resource Center for Adoption. Dr. Rose Handon is a licensed social worker and retired Human Services Administrator from the Ohio Department of Job and Family Services. In Ohio, she had oversight of all child welfare programs and policies. She has played an integral role in providing state agencies with technical assistance and consultation on understanding and complying with Title VI of the Civil Rights Act of 1964 and the Multi-Ethnic Placement Act of 1994 as amended by the Interethnic Adoption Provisions of 1996. Welcome, Rose.
Thank you, Melinda, and I appreciate that introduction. For our participants, we are excited that you have chosen to be back with us again for this important subject matter. We encourage public administrators, practitioners, and private provider stakeholder agencies to advance the discussion about MEPA and Title VI inside your organizations. This will ensure an opportunity for ongoing attention toward improved practices and or policies governing placement decision-making for children in care. On our panel today, I would like to introduce our fellow colleagues and panelists. First is Meg Goldberg, who is a mediator in Portland, Oregon. And Meg contracts with Oregon's Department of Human Services to provide cooperative adoption mediation. She is a consultant with the National Resource Center on Adoption, providing technical assistance in the areas of post-adoption communication and mediation, and MEPA IEP. Secondly, we have Deborah Goodman, who has worked for the Oklahoma Department of Human Services for 37 years. She has been with the adoption section at the state office for 22 years. She began her tenure with the state office as a program field representative, overseeing minority adoptions and recruitment. Ms. Goodman held a key position in the development and implementation of the SWIFT Adoptions Program that she currently oversees. She also serves as the Oklahoma Program Administrator for Adoptions, and her area of expertise is in the area of recruitment and special needs adoptions. This is part 2 of a 2-part webinar presentation. Part 1 was presented on January 28, 2014. Both parts of this webinar series are being recorded, and the recordings will be posted as a resource on our website, www.nrcadoption.org, along with both PowerPoints and the handouts entitled MEPA References and Other Resources. We will send out email notifications when the recordings are available. Please note for today, the curriculum for this webinar has been written and authorized by the U.S. Department of Health and Human Services, Administration for Children and Families, and the Office for Civil Rights. As a result, it is critical that we deliver the content using the language that has been approved by our federal partners. We realize that some participants may have questions concerning the intersection of MEPA and ICWA, the Indian Child Welfare Act. Participants who would like additional information about the intersection of MEPA and ICWA are encouraged to contact their ACF regional offices, who will work with the ACF Policy Division to respond to your specific inquiries. Some information may also be available at the U.S. Department of Health and Human Services Child Welfare Policy Manual, Section 4.3, MEPA/IEAP, Guidance for Compliance, and Section 9.2, Tribes, Indian Tribal Organizations, Application of Title 4E Eligibility Requirements, where you will find related discussion concerning MEPA and ICWA, specifically on Question 10. We will now address some of the key questions that were raised during Part 1 of this webinar series. We ask that all of our participants review Slide 5. Now, we have not placed the questions directly on your screen, but we will identify select questions that have been presented by our colleagues from the first webinar, and I'm going to ask Meg to begin with the question, how can counties honor youth requests for a specific ethnicity of their families? Meg.
Great. Thank you, Rose. So the first question to be considered and answered is whether the youth meets the age requirement of the state to consent to his or her adoption, and if this is applicable for your state. If so, then adoption agencies must consider all factors that may contribute to a good placement decision for a child, and that may affect whether a particular placement is in the best interest of the child. The agencies may assure themselves of the fitness of their work in a number of ways, and this may include case review conferences with supervisors, doing peer reviews, judicial oversight, and quality control measures employed by state agencies and licensing authorities. In some instances, it is conceivable that for a particular child, race, color, or national origin would be such a factor. Permanency being the sine qua non of adopted placements, monitoring the rates of disruption or dissolution of adoptions would also be appropriate. So where it has been established that considerations of race, color, or national origin are necessary to achieve the best interest of a child, the factors should be included in the agency's decision making and would appropriately be included in reviews and quality control measures such as those described above.
Thank you, Meg.
Sure.
The second question that we're going to look at today is if a family voluntarily shares why they are interested in a specific RCNO, do we as agencies, do we have a right to explore their motivations further? And do we even document what the prospective parent is even saying? And I will respond to that question. I will beg for your patience because it is a fairly long response. But here again, we're looking at a family is specifically asking for an RCNO, and how do we as agencies, how do we document that information? So in the response, the answer is yes. Consistently document the expressed interest of a prospective parent or applicant. Further, in making decisions about placing a child, whether in an adoptive or foster setting, a public agency must be guided by considerations of what is in the best interest of the child in question. The public agency must also ensure that its decisions comply with statutory requirements. Where it comes to the attention of a public agency that a particular prospective parent have attitudes that relate to their capacity to nurture a particular child, the agency may take those attitudes into consideration in determining whether a placement with that family would be in the best interest of the child in question. The consideration of the ability of a prospective parent to meet the needs of a particular child should take place in the framework of the general placement decision, in which the strengths and weaknesses of prospective parents to meet all of a child's needs are weighed so as to provide for the child's best interest. And the prospective parents are provided with the information that they need realistically to assess their capacity to parent a particular child. An important element of this is good social work practice in this process, which is the individualized assessment of a prospective parent's ability to serve as a foster or adoptive parent. Now, as we talk about this assessment, it can include an exploration of the child, the type of child with whom a prospective parent might comfortably form an attachment. It is appropriate in the context of good practice to allow a family to explore its limitation and consider frankly what conditions, for example, if a child has disabilities or there is a number of children in a sibling group or children of certain ages, the family has the right to talk about those limitations and what their wishes are in terms of what they would be willing or able to accept. The function of assessing the needs and limitations of prospective foster or adoptive parents in order to determine the most appropriate placement considering the various individual needs of a particular child is an essential element of good social work practice, and it is critical to an agency's ability to achieve that in the best interest of a child. Therefore, the assessment function is very critical, especially in adoptive parents and placements, to minimize the risk that placements might later disrupt or even dissolve. So the assessment piece is very, very critical. Now, as we continue to talk about the assessment piece for our prospective parents, let's note that the assessment function must not be misused as a generalized racial or ethnic screening. The assessment function cannot routinely include considerations of race or ethnicity. The department generally does not distinguish between foster and adoptive settings in terms of the agency's consideration of the attitudes of prospective parents. However, it is possible that a public agency may attach different significance in assessing the best interest of a child in need of a short-term or an emergency placement. Agencies are not prohibited from discussing with prospective adoptive or foster parents their feelings, attitudes, preferences regarding caring for a child of a particular race or ethnicity, just as they discuss other individualized issues related to the child. Here's the caveat. However, as the department has emphasized, any consideration of race or ethnicity must be done in the context of individualized placement decisions. Finally, an agency may not rely on generalizations about the needs of children of a particular race or ethnicity, or on any generalizations about the abilities of prospective parents of one race or ethnicity to care for a child of another race or ethnicity. And we'll have Meg take on the next question. And that question is, we indicated that MEPA and Title VI do not require agencies to seek or use outside professionals to conduct individualized assessments. However, I thought the law indicated that a licensed professional conducting the assessment shall not be employed by the Public Children's Service Agency or child placing agency, public child placing agency, or private child placing agency. I apologize, making a referral. Meg, we'll have you weigh in on that.
Great. Thanks, Rose. It's a good question. So just for clarification purposes, agencies may seek or use outside professionals to conduct the individualized assessment on children. And then if the ACF and or OCR have made a finding against the Title IV-E agency and have entered into a corrective action, then the agency has to comply with what is in the corrective action and in the resolution plan. For all other agencies, however, the law, regulations, and the policy do not require that the person who makes an individualized assessment is someone who is not employed by the Title IV-E agency.
Thank you, Meg.
Yeah.
The next question, are there repercussions for violating MEPA and Title VI? The answer is yes. However, we will further address this question during Part 2 of the MEPA and Title VI webinar on today. Meg?
Yeah. So the next question that we had come up was, is it okay to put adoptive parents' RCNO on the home study? And the answer to that is yes, it is okay unless the Title IV agency is under a corrective action resolution plan with ACF and the OCR. And we'll be talking more about what the corrective action resolution plan, identify that, define that for you all later on in the presentation.
Thank you, Meg. Well, we had a question, a very interesting question as well. We had a stream of great questions. And again, we apologize we can't answer all of them, but we did select some key questions that we felt were very common for the field. In the following question, we were asked, we write home studies, and sometimes a placing agency may ask us how a prospective family would address cultural competence for placement of a child of a different RCNO from their own. Are they, the placing agency, allowed to ask us to explore this? This would be before an individual child has been matched or identified. And in our response to this question is no. There may not be any routine consideration of race, color, or national origin in any part of the foster care or adoption process. Any assessment of an individual's capacity to be a good parent for any child must be made on an individualized basis and based upon a particular child's individualized needs. That requires an individualized assessment of the child's total needs and an assessment of a potential adoptive parent's ability to meet the child's specific needs. Meg?
And then another question that came to us is, can an agency target its recruitment of specific RCNO groups if the data supports that certain RCNO groups are underrepresented? And the answer to this is yes. That is the purpose of the diligent recruitment provision. And in order to comply with the diligent recruitment provision, MEPA allows for the targeted recruitment to increase the number of minority families in the pool of families available to provide adoptive or foster family homes. The Title IV-E agency may conduct targeted recruitment activities for a special population itself, and or it may also utilize the services of a private recruitment agency based on that agency's understanding of the needs of its specific community. However, targeted recruitment activities cannot be the only vehicle used by the Title IV-E agency for identifying families for minority children. The overall recruitment program of the Title IV-E agency must be open to all qualified families regardless of race, color, or national origin.
Thank you.
I'll turn the last question over to you, Rose.
Thank you. And for our listening audience today, on this last question that we're going to present to you, there is an extensive response. So both Meg and I will split our responses. The question is, what are the most frequent errors associated with agencies that violate MEPA? And on today, we will be talking about what happens when a violation has been suspected or identified or reported. But we'd like to give you some examples of impermissible activities in response to a denial or delay of a placement. Now, MEPA reflects Congress's judgment that children are harmed when placements are delayed for a period longer than necessary to find qualified families. The legislation seeks to eliminate barriers that delay or prevent the placement of children into qualified homes. In particular, it focuses on the possibility that policies with respect to matching children with families of the same race, culture, ethnicity may result in delaying or even preventing the adoption of children by qualified families. It is also designed to ensure that every effort is made to develop a large and diverse pool of potential foster and adoptive families so that all children can be quickly placed in homes that meet their needs. In the context of child placement decisions, the United States Constitution and Title VI of the Civil Rights Act of 1964, Title VI, forbids decision-making on the basis of race or the ethnicity unless the consideration advances a compelling governmental interest. The only compelling governmental interest in this context is protecting the best interest of the child who is to be placed. Moreover, the consideration must be narrowly tailored to advancing the child's interest and must be made as an individualized determination for each child. An adoption agency may take race into account only if it has made an individualized determination that the facts and circumstances of the specific case requires the consideration of race in order to advance the best interest of the specific child. Any placement policy that takes race or ethnicity into account is subject to strict scrutiny by the courts to determine whether it satisfies these tests. Now, practices that clearly violate MEPA or Title VI include statutes or policies that, 1, establishes time periods during which only a same race or ethnicity search will occur, 2, establish orders of placement preferences based on race, culture, or ethnicity, 3, requires caseworkers to specifically justify transracial placements, or 4, otherwise have the effect of delaying placements either before or after termination of parental rights in order to find a family of a particular race, culture, or ethnicity. Other rules, policies, or practices that do not meet the constitutional strict scrutiny test would also be considered as illegal. Now, as we have answered that particular question, we would like to provide you with examples of what is meant by delay and denial of placement in foster care, excluding situations involving adoptions. And these examples will be further discussed by Meg. Meg, if you will just address those first 3, and I'll take the latter 3.
Okay, great. Thanks, Rose, because this was definitely a question that had come up and is a source of some confusion around what are examples of delay or denial in foster care placements. So one example, and these are true situations that have come up. A white newborn baby's foster placement is delayed because the social worker was unable to find a white foster home. The infant is kept in the hospital longer than would be otherwise necessary and was ultimately placed in a group home rather than being placed in a foster home with a minority family. Another example.
Meg, as you have mentioned that, I can just see some of our participants saying, "No way," but we certainly want to emphasize that these are real live examples that have happened across the field.
Yeah, thanks. They definitely are. And another example of this is that a minority relative with a guardianship over 4 black children expressly requested that the children be allowed to remain in the care of a white neighbor in whose care the children are left. The state agency denied the white neighbor a restricted foster care license, which would have enabled her to care for the children. The agency's license denial was based on its decision that the best interest of the children required a same-race placement, and that in turn will delay the permanent foster care placement. There was no individualized assessment or evaluation indicating that a same-race placement was actually in the best interest of the children. And then another third example of delay or denial in a foster care placements where 6 minority children required foster placement, preferably in a family foster home. Only 1 minority foster home was available, and it was only licensed to care for 2 children. The children remained in the emergency shelter until the agency could recertify and license the home to care for the 6 children. The children then remained in the emergency shelter even though a white foster home with capacity and a license to care for the 6 children was available. And then if you'd like to, Rose, take the next one.
Certainly. We did see an example, real live example, where different standards were applied in licensing white versus minority households that resulted in the delay or denial of the opportunity to be foster parents. We also have seen foster parent applicants that were discouraged from applying because they were informed that the children that were waiting were of a different race. And then in our final example, we have seen where placement delays and denials had occurred when state agencies had expended time seeking to honor the requests of biological parents so that the foster parents could be of the same race as the child. And so those are just some examples that we certainly wanted to share with the field before we continued on with Part 2 of Understanding and Complying with Title VI of the Civil Rights Act of 1964. Now we're going to go ahead and move on to the next slide. Slide 6 is where we should begin. Great. And I'm going to ask Meg if you'll take it from here.
Great. Thanks, Rose. So some of this is a review from our webinar from Part 1, but it's this part on race, color, and national origin is very important, so we wanted to just go over the definitions again in beginning the second part of this webinar. So RCNO refers to race, color, and national origin. And race is defined as Asian, Black or African American, white, Native Hawaiian or other Pacific Islander, and American Indian or Alaska Native. Color refers to skin tone or complexion, and national origin is a child or a parent's ancestry. And some examples of national origin would be Hispanic, Ukrainian, or Filipino. The discrimination on the basis of ethnicity is encompassed by Title VI's prohibition against national origin discrimination. And MEPA and Title VI do not address discrimination on the basis of religion, age, gender, culture, sexual orientation, or any other characteristic.
Great. Thank you, Meg. We wanted to revisit RCNO as we had posted on last week because that seemed to be a repeat question that came to our attention. So we thought that by emphasizing what RCNO is, that would be helpful to our participants for today. Here are the areas that we're going to further discuss on today, and we're going to look at biological and prospective parent requests. We'll look at the respective roles of the Office of Civil Rights and the Administration for Children and Families. We'll look at the enforcement of Title VI and MEPA. We'll examine compliance tips. And we will also have the opportunity to hear from one particular state, Oklahoma, where Ms. Goodman will share the Oklahoma experience relative to MEPA.
Great.
Here are our key objectives for today. We're going to explore values and assumptions regarding RCNO in foster care and adoptive placements. We'll explore the requirements of MEPA, and we'll explore the requirements of Title VI and how they are linked to MEPA. We also want to explore some MEPA and Title VI practice issues. And we also would like to increase the knowledge of placement practices that comply with MEPA and Title VI, and further to increase knowledge of corrective action and financial penalties related to the noncompliance with MEPA and Title VI. Meg?
Great. So, I'm sorry, we're on slide 10.
The competency?
Yeah.
We're on slide 10.
Sorry, I saw it move and then I kind of lost my spot there. So we're going to then further identify tools and techniques that will help prepare families to make informed decisions and also to help the agency support them in those decisions. And then we will also define and implement action strategies to ensure that practice is compliant with MEPA and Title VI. At the end of this webinar, participants will be able to identify their own personal values and how they impact their professional practice, and also identify the impact of MEPA and Title VI on recruitment and placement activities. And now I'll turn this over to you, Rose, to talk about biological parent requests.
Thank you. And as mentioned earlier, and even on last week, we ended one of our sessions with regards to the biological parent request. And that seems to be a very popular inquiry from the field. And we'd like to acknowledge for both voluntary and involuntary removals, an agency may not consider or honor the request of parents or legal guardians to place their child or youth with foster or adoptive parents of a specific RCNO. In addition, this applies to birth parents who are considering placing an infant for adoption. As we talk about prospective parents and their requests, we're going to explore that prospective parents may make requests about any characteristic that they want in a child or youth, including RCNO. Agencies are not required to place a child or youth of a particular RCNO with a parent who has indicated that the parent does not want to parent a specific child or youth of that RCNO. Agencies must be as flexible with prospective parent requests related to RCNO of a child or youth for whom they will provide a home as they are with parents' requests related to other characteristics of a child or youth. If an agency presents children or youth whose characteristics do not match the parent's request, the agency must be similarly flexible with presenting children or youth whose RCNO does not meet the parent's request. We are on slide 14.
Great. And so then also the other thing to consider are family and community ties. And the Child and Family Services Review, the CFSR, assesses whether a state is making the concerted efforts to maintain a child or youth's important connections. And these connections may include ties to his or her community, his or her neighborhood, and school. The Administration for Children and Families recognizes that in many cases it's a good idea to help a child or youth preserve those ties, especially when the child or youth is expected to be reunified with his or her parents or a family member in the same neighborhood. Making this concerted effort to make a child or youth's important connections is not a violation of MEPA or Title VI. And with photo listings, an agency may identify or document the RCNO of a child or youth who is featured on an adoption website such as Adopt Us Kids, and their website is at www.adoptuskids.org. And the agency may also design and administer adoption listing websites that allow prospective adoptive parents to search for the child or youth profiles based on the child or youth's RCNO. The agency must treat RCNO in the same manner it treats other characteristics, including the age, gender, and membership in a sibling group. An example of this is if the agency identifies a child or youth's RCNO on its website, it must also identify other characteristics, or if an agency allows prospective parents to search for a child or youth by RCNO, it must also allow prospective parents to also search by other characteristics. And now we want to take a few minutes for questions.
As a reminder today, with our PowerPoint presentation was included a downloadable file with yesterday's webinar reminder email. Also, in this email, a post-meeting email will be sent to all participants, which will include the downloadable PowerPoints from today's presentation. As Meg has stated, we will now pause our presentation for approximately 10 minutes to address any questions that you may have. To submit your questions, type them in the chat window, which is located at the left of your screen. For those who would like to speak directly with the presenters, you must join the audio portion of this webinar by calling 1-800-763-6049.
And Mark, would you please give any further instructions to the participants about submitting their questions, please?
Absolutely. Ladies and gentlemen, if you'd like to register for a phone question, please press the 1 followed by the 4 on your telephone. You'll hear a 3-tone prompt to acknowledge your request. If your question's been answered and you'd like to withdraw your registration, please press the 1 followed by the 3. One moment, please, for the first phone question.
Thank you.
And ladies and gentlemen, as a reminder, to register for a phone question, press the 1-4. And our first phone question comes from the line of Lori. Please proceed with your question.
Sure. I just want to clarify. I'm working with a birth mom who's pregnant and making an adoption plan, voluntary relinquishment, and she cannot say that she wants us to find a family of the same race as her.
Meg, please.
That is correct.
She's voluntarily relinquishing her parental rights and wants to choose the parents that will raise her child. She cannot say, I'd like them to be in the same race as I, RCNO.
That's correct. That the biological parent, whether it's a voluntary or involuntary, that the agency may not consider her request.
Could you expand more? I find that appalling professionally and ethically. So could you talk a little bit more why we couldn't honor her request?
Well, we have a federal law that says that RCNO may not be considered in the placement and the selection of children, and I believe that as difficult as it may appear or sound, that we are being consistent with that position, in support of our federal legislation. Now, in your counsel with the birth parent, they may express their interest. However, we cannot honor that request specific to an RCNO.
So if they're really clear on that and feel very strongly based on some other things that have happened to them, all of the other private adoption agencies, as opposed to our public adoption agency, they're also required. So she can't go anywhere to make that placement like she would like.
The public or private child welfare agency may not honor that request. It would be considered as a violation if RCNO was being used in the selection and placement of that child.
So her only choice would be to do an independent adoption, and that's not required? MEPA is not required
We're
for
not
that?
in a position to identify what the birth parent's options are. All that we can affirm is that RCNO may not be used in a voluntary or involuntary placement of that child.
But if I'm doing pregnancy counseling with her and I'm trying to help her make the best decision that she would like, part of that is giving her appropriate resources, community resources.
You certainly may give your parent and your client resources, but again, RCNO cannot be utilized in the placement decision-making process for the placement of the infant.
Wow. Okay.
But thank you for your question.
And there are no further phone questions at this time.
Okay, for the presenters, we have a question from Nancy, and she asks, sometimes birth parents review home studies and pick a family. Are they doing this against an RCNO?
We certainly would need to further entertain that question with our Children's Bureau because we're not knowing the particulars of that agency practice with regards to the birth parent making selections. We would have to advance that conversation further with our Children's Bureau representative for policy clarification and direction. Thank you for the question.
We have a question from Carla. Carla asks, do we honor the request of the child above the RCNO he or she is placed with?
I do believe that we addressed that earlier in our one of our questions, but Meg, if you would just revisit about the child's position on the selection of a placement relative to RCNO, if you can just revisit that response.
Yeah, and so that, and it often comes up with that, and the first part of that is to look at and see if you have an applicable state law, state statute in your state that defines the age of consent for the child or youth that's in that is being placed. And so if there is an applicable state age statute, then that child meets that. That's the first piece to get over, that the child then can make that request. Along with it, though, is that remembering to really consider all other factors that may contribute to the placement decision for that child, and making sure that that particular placement is going to be in the best interest of the child. And some of that may be, even if the child meets the age requirement, is still looking and seeing if it may be something that you might want to still look at to do some sort of individualized assessment.
Thank you, Meg. I do want to have us go back and revisit the conversation relative to the birth parent and their counseling by the social worker relative to the parent's interest on the placement of their baby and their infant. And so just wanted to add to the conversation that MEPA will only apply to Title IV-E agencies and those agencies in which they contract. So in this particular situation, if it's a private agency that does not receive federal financial assistance, they are not bound by MEPA/IEP. So again, MEPA only applies to Title IV-E agencies and those agencies in which they contract. So if in this situation, as the caller had suggested, if this is a private agency relative to services to that birth parent, if it's a private agency and they do not receive federal funds, then they would not be bound by the rules of MEPA. And thank you for that original question. Are there any additional questions on the phone?
We have another chat question from Annette. The RCNO cannot be the factor in the selection of the placement, although if the placement resource equals the RCNO of the parent along with other factors of the assessment, is that acceptable? Does this apply to nonprofits and private agencies? And I think you might have answered part of that.
Yes, I did answer part of that relative to private agencies. However, it's going to be very important that individualized assessments be considered in this particular question. So it's kind of difficult to say because all things will not be considered equal relative to this process. However, it is going to be important to conduct an individualized assessment of the child as well as the prospective parents to determine what is in the best interest of the child. RCNO, as we mentioned last week, may be entertained in some situations, but it's going to come down to assessment and documentation. And as Meg has suggested earlier, if there is a legal age of consent in which a child expresses what their interests are relative to an RCNO, and that child is of legal age and has been counseled and has understanding in the placement decision-making process, then again, documentation becomes very, very key. Thank you for that question.
And before we move on, Mark, did you have any more call-in questions?
None at this time.
Thank you for those questions. We're going to move on, and next we will be on slide 17. I'm going to ask Meg to weigh in on the respective roles of the Office for Civil Rights and the Administration for Children and Families.
Great. Thanks, Rose. So the OCR and ACF work together to help states ensure that their child welfare laws, policies, and practices do not result in the discrimination against children, youth, or families on the basis of RCNO. OCR and ACF administer different statutes and have different complementary responsibilities. So first, looking at the OCR, the Office of Civil Rights enforces Title VI and the civil rights provisions of MEPA. It will also investigate complaints and conducts compliance reviews to ensure compliance with the law, such as interviewing agency staff and prospective or current foster or adoptive parents, and will also examine data systems and case records. The Office for Civil Rights makes determinations of compliance or noncompliance and attempts to resolve noncompliance first through voluntary means. The Office of Civil Rights may initiate proceedings to terminate federal financial assistance, or it may refer a case to the Department of Justice where compliance cannot be secured through voluntary means. It will also provide technical assistance to help ensure voluntary compliance with the law. Now, the ACF administers Title 4B and 4E of the Social Security Act. The ACF will ensure that states comply with their Title 4B and 4E state plan requirements, and this includes the diligent recruitment provision and MEPA. It will also respond to questions from states about diligent recruitment and MEPA. The ACF may issue a penalty if it finds that a state has violated its MEPA state plan requirements, and help states ensure that their child welfare systems are free from discrimination on the basis of RCNO. And OCR and ACF can become involved in MEPA issues in several ways. Through the Child and Family Services reviews, through an internal state agency whistleblower. They may become involved through a prospective parent complaint, or through civil rights compliance reviews, through private litigation, and other ways.
Meg, if I can just kind of interject,
yeah. Sure.
as we look at other ways, there may be an example that might be considered, and that could actually be through a news article or a news release. And if OCR or ACF receives notice from even a news article of a complaint that may have come through the media, they can also become involved in that way. So that is an example of what other ways might be. Thank you.
Great, thanks. And then, so with OCR and ACF, specifically OCR investigates the potential violations, and then OCR and ACF will share information related to allegations of violations in OCR's investigations. If the Office of Civil Rights Investigation reveals a violation, then OCR may submit a letter of findings, known as the LOF, to the state that details their findings. ACF then reviews OCR's investigative file and its LOF to determine whether the state has violated either its Title 4E state plan requirements or the MEPA implementing regulations or policy. OCR and ACF will coordinate on technical assistance, training, and enforcement actions. Now there's two types of MEPA and Title VI violations, and Rose had actually given some examples of that when we were doing our Q&A at the beginning. And an individual violation is a discrimination against a specific and identified prospective parent or a child or youth in the state's care. And then a systemic violation is a non-compliant law, policy, practice, or procedure. An example is state law or policy that is inconsistent with MEPA, or a home study form that requires or advises caseworkers to practice in a manner that may be inconsistent with MEPA. An enforcement of Title VI and MEPA with individual violations. If the ACF and OCR find that the state has discriminated against an individual, then ACF and OCR will require the state to enter into a corrective action and resolution plan known as the CARP. If ACF finds that the state has committed an individual MEPA state plan violation, ACF will assess a penalty against the state's Title 4E foster care maintenance and adoption assistance funds, against the state's administrative cost funds, against its training funds, against its Chaffee foster care independent living allotment, and private agencies that violate MEPA must also return to the federal government all Title 4E funds that it has received for the quarter in which it was notified of the violation. And if the ACF and OCR find that a state has maintained laws, policies, practices, or procedures that do not comply with its Title 4E state plan or Title VI, ACF and OCR will require the state to enter into a CARP that is designed to remedy the violations. And this is in regards to the systemic violations. Elements of the CARP might include notifying past prospective parent applicants of this violation, training agency and contracting staff, providing regular data and reports to ACF and OCR, and revising their non-compliant laws and policies. And the state may appeal the ACF's finding of state plan violations and penalties and the OCR's finding of civil rights violations to the Departmental Appeals Board, and that's the DAB. If the state disagrees with the DAB's decision, it may then appeal to the U.S. District Court and avail itself of full federal appellate process. So some states have county administered systems in which the states delegate responsibility to the counties to administer the state's Title 4B and Title 4E plan. And if this is if you're in this county administered system under Title 4E, the state will be held responsible for county violations of state plan requirements. under Title VI, counties are directly responsible for their violations of Title VI. States will be required to take steps to ensure compliance by county agencies that violate MEPA or Title VI. And if the state violates MEPA or Title VI, the state will be responsible for ensuring that it successfully completes all corrective actions that OCR and ACF require. Rose, would you like to address the next one?
Certainly. The enforcement of Title VI and MEPA examples are as follows. Now, these are real live examples, and OCR has found violations in cases where an agency manipulated a data system to broaden the search for children or youth with respect to all characteristics but race, when children or youth meeting parents' requested characteristics were not available. In another example, an agency adopted and implemented a policy that required workers to ask more questions or more detailed questions to families that were interested in transracial adoption as part of the home study process. In another situation, we found that an agency had matched a child or youth to prospective parents based upon the complexion of a child. And in another situation, we had an agency who had honored the request of a young child to be placed with a parent based upon RCNO, even though the state law age to consent was significantly older than the age of that particular child. These are just examples. Many more could be cited, but these are some highlights that we wanted to share today. On our next slide, other examples required prospective adoptive parents to even attend a house of worship that had a different RCNO composition than the house of worship in which the family attended in order to adopt a particular child or youth. We also have an example where an agency required prospective adoptive parents to subscribe to periodicals or magazines that workers believe reflected the child or youth's RCNO. And in another example, an agency generally subjected parents who were interested in transracial adoptions to a higher degree of scrutiny. Now, as we look at compliance, and ACF and OCR will examine the facts of each case where a MEPA and Title VI violation may have occurred. Because each case is determined based upon the specific facts and circumstances of each allegation, ACF and OCR cannot provide a list of documents that will insulate a state agency against the findings of a MEPA or Title VI violation. But your documentation and your case records, whether they're electronic records or manual records, are very, very important. So documentation in the decision-making process is very essential. As we look at slide 30, if the agency decides to consider RCNO when making a placement decision, the agency may want to consider creating a record of documents that relates to the following. Who was involved in making the decision to consider RCNO, including any supervisors or even administrators involved in making those decisions? Secondly, the agency's process for deciding to consider RCNO. For example, whether the agency conducted the individualized assessment or sought out the input of an outside professional, as we discussed previously. In addition, whether the agency advised outside professionals that federal law prohibits the routine consideration of RCNO, and whether the outside professional interviewed the child or youth and or reviewed the case file. Again, document, document, document. As shown on slide 32, when the agency declines to place a child or youth with a prospective parent and the reason relates to RCNO, for example, the parents have made comments that causes concern as described in the case file, that must be recorded in much detail as possible. The RCNO-related reasons that makes the prospective parents an unsuitable placement option. Documentation is very critical here. What we have found throughout the field as we have presented this particular curricula is that agencies may have concerns, or even maybe a secretary captured some concerns about a prospective family. And in such case, the concerns were discussed in the office but never recorded in the file. So again, it is very important that for those situations where you have concerns about a prospective parent or placement, and it is RCNO related, where those concerns are duly recorded, please assure consistency in documentation. Also, for agency actions, the agency staff should work together to ensure compliance with MEPA and Title VI. For example, the agency may want to consider developing a peer review process in circumstances in which a worker thinks it is necessary to consider RCNO as part of the placement process. The agency may also want to consider developing a supervisory chain of command process for managers to review and advise on the issue. I do want to go back and revisit slide 31. I believe I may have inadvertently skipped that, so we can just go backwards a bit. When we're looking at, and we're talking about documentation again, when we're looking at the results of an individualized assessment and the rationale for the conclusion or recommendation, we want to clearly have that documented. We also want to document how the decision to consider RCNO was narrowly tailored to advance the child or youth's best interest. And we also want to assure any document that reflects the details of the selection or placement committee, if such exists. For example, who was present, which families were presented, what discussions took place about the families, and document why a family was or was not selected for a particular child or youth. And I believe we are at slide 34. As we talk about continued compliance tips, training public agency staff. Other actions that the state may take to facilitate compliance may be to train agency staff and its contractors on MEPA and Title VI. I cannot underscore that. We cannot underscore that enough. That training agency staff and your contractors, both public and private, on MEPA and Title VI is very, very critical. We also would recommend that you consider providing MEPA and Title VI training to all new employees and offer or require that staff take refresher courses on the law and policy. Further, ensure that all of the entities with which the state contracts with knows how to apply MEPA and Title VI to their daily practice. And we mentioned earlier that if the state contracts with a private agency, that your private agency is just as vulnerable and culpable if any violations occur, and the state is responsible for the actions of their private providers. Here are some legal and regulatory and policy authority citations. I certainly won't read those to you, but these citations are of importance. It is an excellent reference site for communities, child welfare agencies, both public and private, that may be utilized for further attention and information. You'll also see toward the end of the slide, after one citation, the Child Welfare Policy Manual and the related child welfare site of interest. And when you go to that URL address, you will receive additional information relative to MEPA. And then in understanding MEPA policies and laws as recorded in October 22nd, 95, the memorandum there at that particular site is of interest and of importance as well. We will now pause our presentation for 10 minutes to address any questions that have come to our attention following this portion of the presentation. To submit your questions, type them in the chat window, which is located at the left of your screen. For those who would like to speak directly with presenters, you must join the audio portion of this webinar by calling 1-800-763-6049.
And we have a question from Robin. And Robin would like to know, what is the time frame for OCR and or ACF to complete investigations?
Thank you for that inquiry, Robin. I will suggest in response to this particular question that the investigative process is very detailed and may be prolonged. I cannot specifically say that it's X number of days because it depends upon the complexity of the case. I will suggest that it is very thorough, is very exhaustive, that our federal partners look at the case records, documentation, and any other supplemental materials, including rules, policies, etc. So again, it depends upon the complexity of the case, all partners that are involved. It is an on-site process, and as well as off-site, etc. Various stakeholders are involved in the process, and it is something that is taken very seriously, and so it is not a process in which our federal partners will just come in and leave. It is a very detailed process, and I thank you for that question.
And right now, Mark, would you open up the phone lines for callers, please?
Absolutely. And ladies and gentlemen, as a reminder, to register for a phone question, press the 1 followed by the 4. And there are no phone questions at this time.
Thank you. I'm going to turn this over to Meg for our next transition.
Great. Thank you, Rose. And so now at this point, we're now going to bring Deb Goodman on to talk about the Oklahoma experience. And so, Deb, would you like to go ahead and take it away?
Sure. Good afternoon. Oklahoma's experience began in the early 2000s when we embarked upon training from our regional office along with the Office of Civil Rights. In that training, we were exposed to the initial concept of MEPA, and it was provided to not only the staff that was involved with resources, but also permanency planning, CPS, and all aspects of child welfare. After that initial training, we were sparked with renewed interest after attending the National Association of State Adoption Managers meeting, where there was a presentation made by one of our fellow states regarding their experience with MEPA. This sparked a renewed interest in providing additional training to not only the resource staff, which I was responsible for, but to make sure that the training would be inclusive of all members of child welfare in the state of Oklahoma. We once again made a request of the NRC for adoption for technical assistance and training in the area of MEPA. After a couple of years of making sure that it was approved by the Children's Bureau, we were afforded the opportunity to participate in the MEPA training as designed by the NRCA. This actually occurred in April of 2010. Once again, we tried to solicit not only adoption and foster care leadership, but we also requested participation from CPS, foster care, permanency planning, adoption, and also our training unit to participate. It was our goal from this training that we would be provided a 2-day training of trainers and that we would be able to take the training out and continue the training with all of child welfare throughout the state. We are a state administered system, and so our thought was that if we could provide the training to trainers, we could keep up the training on a regular basis. After the completion of that training for trainers, we noticed a couple of things were happening. One, every time we would bring up the subject of how we would move forward with the training, we would get comments from most of those in attendance of their reluctance to provide the training. The reluctance was primarily around feeling uncomfortable about the subject matter, afraid of not articulating everything correctly, and just somewhat of an avoidance of moving forward. After the training of trainers, we had the opportunity to participate in the MALDI Institute, or the Minority Adoption Leadership Development Institute, and decided that one of the topic that we would suggest that we would like to be involved with in MALDI would be around MEPA. And as a part of this training, we were able to have an objective of our MALDI project. We wanted to impact permanency for children. We wanted to make sure that we utilize MEPA as a tool to educate. We wanted to have a consistent message regarding MEPA for all of the child welfare staff. And most importantly, we wanted to debunk the fears surrounding MEPA. As a part of our MALDI project, we had envisioned an opportunity to develop an online training. We wanted to make sure that we first started with the leadership of child welfare. We would bring everybody up to speed regarding MEPA, but we also wanted to make sure that our staff would be trained on a regular basis, that our vendors would be included in all of our training, and that they would, more importantly, include MEPA into their recruitment planning. We also wanted to make sure that our private vendors had an opportunity to complete training on an ongoing basis regarding MEPA. After our MALDI, we wanted to continue on as a result of the MALDI project, and as a result we had a recruitment conference where we invited all of our resource staff along with our private vendors in 2012, and we brought forth the trainers who had been engaged with us regarding the TOT once again to our state, and they were responsible for presenting a workshop with all of our resource specialists, as well as we had invited some of our private vendors. Oklahoma has continued in their training of MEPA throughout our state, and it is our hope that we will continue to progress. And the way of progression, we have developed our online training that we are using and requiring all of our resource staff to participate on an annual basis. We now have many more private vendors than previous, and we are including that language in our contracts that they must also include MEPA training, and more importantly, they must exercise the portion of MEPA regarding diligent recruitment of families that look like the children that we have in care. Because of our experience, we have made links and interrelationships between not only MEPA but MALDI, also the Diligent Recruitment Grant. We were able to develop the online training, and eventually a strategic partnership was developed with the University of Oklahoma. As we developed the online training in conjunction with the Children's Bureau, who had oversight on this training and final approval of this training, we now have been able to make sure that a consistent MEPA training is provided to all of our resource staff. We have gone from approximately 100 participants to now this year, I think our final number was up to almost 400 participants attending MEPA training online. We are moving it forward to include our private vendors. We made arrangements for them to now, and for the private vendors along with their subcontractors to also participate in the online training of MEPA. And this is through a partnership with the Oklahoma University, who created this online training. In addition to the training being mandatory for our resource staff and partners, we also have it available for our foster and adoptive parents who may also have access to the training. In moving forward, Oklahoma's plan is to include this online training for our new workers. Our plan is to continue to make it a yearly requirement for all of our resource staff. Our plan is to make it a requirement for all of our contractors that are involved in recruiting of adoptive or foster homes. And in addition, we're trying to make it an annual requirement for our permanency planning staff, who actually make the placement decision for children that are in care in the state of Oklahoma. So we are looking forward to continuing our training for all of our staff along with our partners as we move forward in our MEPA experience. Oklahoma has increased the mandated MEPA training for all those who are a part of our child welfare system. We still have work to do, but we believe that as a result of that start back in 2000, we have progressed, but we want to continue on. If there are folks out there who have a continued or maybe have an interest in our online training, they may contact the University of Oklahoma, who is more than willing to make this available to other states, tribes, and territories for a fee. And those who wish to learn more about the web-based training can contact Vince DeBerry, who is the Executive Director of the Center for Public Management at the University of Oklahoma. His email address is vince@ou.edu, or you may contact him via the phone at 405-325-0519. This is a summary of Oklahoma's experience with MEPA training. It has been a unique experience for us and one that we have grown and hope to continue to grow.
Thank you, Deb. In terms of resources and technical assistance, we certainly encourage you to contact your Administration for Children and Families or the Office of Civil Rights Regional Office with any questions about how to implement MEPA in Title VI. We encourage you to ask your ACF and OCR regional offices to review any proposed training material or curricula before using it to ensure that it complies with MEPA in Title VI. We certainly encourage you to keep current about information that ACF and OCR releases about MEPA in Title VI on any websites. Remember that ACF and OCR wishes to partner with your state to ensure that your child welfare system is fair to the children and youth and families who are involved with the child welfare system. Further, we want to ensure that we are free from discrimination based upon our CNO. We are here to help you prevent violations and to help you correct them should they occur. Other resources and technical assistance regarding MEPA can be obtained from the National Resource Center for Adoption. And our email address again is nrc@nrcadoption.org. Our phone number is 248-443-0306. For further information, you also may receive information about the Navigator tool, which provides assistance for developing recruitment plans from each state. I apologize. It looks like that PowerPoint is just moving around too fast. And again, that information on Navigator tools or developing recruitment plans may be done by contacting our sister partners at the National Resource Center for Diligent Recruitment at Adopt US Kids or Adopt Us Kids. And the email address is nrcdr@adoptuskids.org, and their phone is 303-726-0198. Again, nrcdr@adoptuskids.org, 303-726-0198. We will now address any additional questions or comments that you may have following our last Q&A period. You may submit your questions by typing in the chat window, which is located at the left of your screen. When finished typing, click on the second button to submit your questions and comments. For those who would like to speak directly with presenters, you must join the audio portion of this webinar by contacting 1-800-763-6049. And we're now open for additional questions or comments.
We have a question from Ruth. She presents a scenario about a family that has been approved. However, the agency and the family cannot agree on subsidy and the placement is denied. Is this a violation of MEPA?
All right, for clarification of that question, I believe I'm hearing that the family has been approved as an approved placement for a particular child, but because the agency cannot agree to the subsidy or adoption assistance package, the placement then becomes denied. Is that what I'm hearing? Ms. Parks?
Yeah, that's exactly what she typed.
There is certainly some potential risk inside that particular scenario. I would say that this is a scenario that we would certainly want to advance onto our Children's Bureau because it does have the implications for particular policy guidance and interpretation for the allocations of adoption assistance settlement between families and the agency. So we certainly appreciate that question, and we will advance that conversation on to our Children's Bureau. Thank you.
And Mark, would you please open the phone lines for additional questions, please?
Absolutely. Ladies and gentlemen, as a reminder, to register for a phone question, press the 1 followed by the 4.
As our questions are coming in, the question that we will advance on to our Children's Bureau I want to be clear with the question that if the placement is being denied on RCNO, there would be a violation. If it is not based upon RCNO, it would likely not be considered a violation. But again, we will advance that on to our Children's Bureau. But I certainly wanted to interject that clarification point. Thank you, Ms. Parks.
And there are no phone questions at this time.
Thank you. Ms. Parks, other questions that may have come through?
There is a question about if there have been any changes to MEPA since the first webinar, the first training that we held in 2007.
I believe that there has been a clarification memo that was tendered in April of 2012 as part of the Child Welfare Policy Manual, certainly relative to ICWA and MEPA, and I do believe that we did have that noted on the first PowerPoint slide, that particular clarification. But other than that, we just had some statistical updates and just some other slight changes to the slides that you're seeing for both Session 1 and Session 2. Thank you.
And at this time, we don't have any additional questions.
Thank you.
Well, we just had one that just came across. We have a question from Nancy. She says that our state has set subsidy rates that are for all parents and are not based on any characteristics on the family, but the special needs of the child, and we can't go above our rates. I do not believe this violates MEPA.
Meg, did you want to weigh in, or otherwise I could just continue on to what we just talked about?
Go ahead and continue on with that, Rose.
Certainly.
Yeah.
As I stated in the previous question in terms of the adoption assistance settlement, if that placement had been denied based upon race, color, or national origin, it certainly would be considered a violation. But in this particular case, as the question has come forward, it does not violate MEPA, and we certainly appreciate the question.
And we have no more questions, Rose.
Thank you. Thank you so much. We're now at the end of this webinar, and as a reminder today, the PowerPoint presentation that was included as a downloadable file with yesterday's webinar reminder email has been made available. As a post-meeting email, such will be sent to all participants, which will include the downloadable PowerPoints from both MEPA presentations. For those that may have additional questions or comments or need additional information, feel free to email NRC at nrcadoption.org or call 248-443-0306. At the end of this webinar, you will automatically be directed to a brief survey provided by Public Research and Evaluation Services, which are the independent evaluators for the NRCA. The NRCA would appreciate your feedback regarding this webinar presentation. Your responses are confidential and will be reported to the NRCA in group summary only. We certainly appreciate your time and attention in the attendance of webinar 1 and 2 for MEPA and understanding and complying with Title VI of the Civil Rights Act of 1964. If you have any additional questions or comments, again, feel free to email us at the address provided. Thank you for your time and attention, and have a wonderful day.
And this is the conclusion of our webinar.